Hi everyone, it's Jeremy here from the McLean Real Estate Group and Remax Camosun in Victoria, BC. A couple times a year we always like to run informational sessions for the general public and help them within their journey of buying real estate. And last week we had Ryan Stenquist from Condo Clear Services come in to talk about the legislative side of stratas and what you as a buyer need to look at when reading through strata documents. The presentation is a little bit lengthy but contains a lot of valuable information for anybody looking to get into a strata complex, which is any condo, townhome, duplex, or bareland strata. So I hope you enjoy all the content and feel free to add any questions that you have into the comments below.
Okay, so a little bit about me. I've got over 10 years experience with strata corporations. I've been an owner, council member. I was a managing broker and regional director for a large strata management company in BC. During that time, one of the big things that I dealt with was warranty situations, which is becoming more and more common, especially in stratas. So under the BC legislation, all new construction is required to have a 2-5-10 warranty. This can be handled in various different ways, but when it comes right down to it, if you find yourself in a warranty situation or looking at a property that's going through a warranty situation, it can be very confusing. So that's one of the key things that I help to review as part of my services. So just out of curiosity, how many people here have experience with strata corporations or have already bought in a strata corporation? Okay, so it looks like about half and half. For those of you that are maybe just thinking about going through this process, there's something called the Form B. So if you're looking at purchasing a strata property and you have an accepted offer, your realtor is going to get you a Form B as well as the supporting documents. So there's typically 2 years worth of minutes, the bylaws, the rules, the financials, and of course the depreciation report. So usually that ends up being about 200 to 400 pages of documents. I take that, I summarize it into about a 6 to 8 page summary, and then of course answer any questions. Again, that includes a depreciation report, but what I do is I just provide a general overview. Basically, it's a snapshot of about the next 5 years. If you want to get into more details, the technical side of things, then that would be under Russ's wheelhouse, which he'll talk about later on. And just, of course, disclaimer, I'm not a lawyer, I'm not an engineer. These reviews are based on my experience with strata corporations, and it's meant as a general overview. If there is some kind of a complicated problem, legal, building, structural, otherwise, then that's something that you can take to a lawyer and have them focus on that. So just a general overview of the depreciation report, which I'm not going to get super into detail on the report itself. I'm going to leave most of that for Russ. But I just want to give you a background on what a depreciation report is and then how financials work in a strata corporation. So a depreciation report is a 30-year projection of capital cost expenditures. So some things like replacing the roof, the windows, doors, common area carpets, pool liner if there's a pool, hot tub, things of that nature. In the depreciation report, they detail all the components, the common property components. So there's two things you need to consider here, is that when you buy into a strata property, you own your unit. So those components within your unit, your countertops, your sink, your floors, etc., those are your property. Obviously the strata corporation is not responsible for those. But there's the shared items, the common property, so things again like the roof, the doors, the windows, hallway carpet, things of that nature. And then what they do is they give you a projection, a 30-year projection, and then they break it down into typically 3 common funding models or possible funding models. So overview of the financials. So under the Strata Property Act, all strata corporations are required to have 2 trust accounts, at least 2 trust accounts. The first one's for the operating account, so that's your day-to-day expenses, and the second one's for your contingency reserve fund, which we'll be talking about more in conjunction with the depreciation report. You may have more than 2 trust accounts. The third one could be for special levies. So special levies come into play if, for instance, there's not enough money in the CRF, or if the strata corporation just doesn't want to deplete the CRF to pay for a specific project. They can solicit the owners through a 3/4 vote resolution and raise that money through a special levy. And of course, this is all split up individually by your unit entitlement, which I'll get into more detail on in a bit. So operating account. again, it's for the day-to-day expenses. So think of it as your checking account. These are the things that you're paying for your landscaping with, gas bills, electricity, those types of items. It's attached to a budget, which is reviewed and voted on every year at your annual general meeting by the owners. So owners in a strata corporation will attend that meeting and vote on that budget. It can be amended at the meeting through another majority vote, so that's something that often happens. And the strata corporation and the council is restricted on what they can spend out of the operating account based on that budget. So depending on the bylaws, I've seen them as low as $1,500. I've seen them as high as $15,000 to $20,000. The council is restricted from spending that money within the confines of that budget and whatever threshold is laid out in the bylaws. So contingency reserve fund. So this is meant for the capital cost expenditures, as I already mentioned. There is minimum standards in place under the Act. So 10% is the minimum. 10% of the operating budget until the fund reaches 25% of the operating budget. This is relatively low. So just for instance, if you had a $100,000 operating budget, the strata corporation would be required to contribute $10,000 a year into your CRF until that CRF hits $25,000. At that point, there's no legislative requirement to put any money into the CRF. I have seen that happen. It's not very common. Most strata corporations are going above and beyond that 25% mark, and rightfully so, because most of your capital cost expenditures are going to be significantly higher than that. CRF funds are permitted to be invested as per the Act. Section 6.11 of the regulations outlines what you can and can't invest those monies in. Fortunately, it is fairly stringent on what you can invest in, so it's restricted to fairly safe investments like GICs are the most common thing, or some trusts and things along those lines. But what I usually recommend to any councils that are wanting to explore their options is talk to an investment person. Expenditures from the contingency reserve fund can be approved in a couple different ways. 3/4 vote used to be the standard. So anytime you want to spend money out of that CRF fund, you'd have to go to the owners at a general meeting. You'd have to have a resolution detailing what the expenditure is for, and have a 3/4 vote approval to spend that. That actually changed 2 or 3 years ago. So items now that are identified in the depreciation report as needing to be done, they've lowered that threshold to a majority vote. So it makes it easier to pass that. Because unfortunately, some strata corporations were actually getting into a situation where work needed to get done, but they just couldn't hit that 3/4 vote threshold just because people didn't want to pay for it for whatever reason. The third way that money can be spent out of the CRF is if it's an emergency circumstance. The Strata Property Act does allow expenditures of that nature. However, it's restricted to the minimum amount required to rectify the situation. So, for instance, say 3 windows in the building got broken. Well, maybe all the windows need to be replaced, but those 3 got broken. You can spend CRF money as an emergency expenditure to replace those 3 windows, but you can't go and replace all the windows. You just say, well, they all need to be done, and it's cheaper if we do them all together. One thing that comes up often is roof leaks. You might have a roof that's maybe in a certain state of disrepair. You're having to repair it on a regular basis just due to leaks. You can spend that CRF money to do those repairs, but you can't spend that CRF money to replace the roof as a whole. So, and the last real financial thing is special levies. So again, like I said, these are required in situations where either the strata corporation doesn't have the money, or sometimes they want to do a hybrid and they want to spend some out of CRF and some via special levy, or maybe they just don't want to deplete the CRF money, because it is good to have a certain cushion there for emergency expenditures if something comes up. As much as we'd like to be able to project everything that the strata corporation is going to run into, it's likely not going to happen. So special levies that are passed by a 3/4 vote, again a resolution at a general meeting. Payment details are within the resolution itself, so depending on how big it is, most strata corporations will give people a month or 2 months to come up with the money. In some circumstances, they will actually have a payment scheme, so you pay X amount of dollars over a 6-month period every month. Those situations you got to be a little bit leery of, or be at least aware of, especially if you're looking to buy in a strata corporation, because in those situations you really have to make sure that A, the realtor knows about the situation, and that your lawyer knows about it, so everything can get cleared up through the conveyance. nothing worse than going through that situation at the 11th hour, find out that there's a special levy and there's been no discussion on who's supposed to pay it. And then in those situations, what can happen from time to time, especially with bigger special levies, is some units just may not have the money to pay it at all. So when it comes to that, strata corporations actually have a lot of power to collect money from owners. They can start with fines, obviously, through the bylaws. Depending on the bylaws, they may also be able to attribute interest to the outstanding amount. Next kind of step would be filing a lien in land title's office, which prevents the unit from being conveyed without having that payment made. And then the last item is forced sales. So the strata corporation can go through a lawyer, request that the courts approve a forced sale action, which is something that 5 or 6 years ago we didn't see a lot of. In the last 2 or 3 years, we're seeing it a lot more often. Mostly because they changed the Limitations Act probably about 3 or 4 years ago, and now you're restricted to 2 years. So basically any amounts that go outstanding for more than 2 years, good luck collecting it after that. So a lot more strata corporations are paying attention to their accounts receivable and going with that forced sale action. Most of the time, in my experience, if there's a mortgage on the property, the lender will pony up and pay the levy and then just tack it onto the mortgage. But I mean, that's not a given. It's fairly common, but I have seen quite a few actually go to forced sale. Okay, so unit entitlement. So this, like I mentioned before, determines your share of common expenses. So this is what you pay in your strata fees. This is what determines your strata fees. So it's for your operating budget. If there's a special levy, it's split by that unit entitlement as well. It's calculated one of two ways, either by the habitable area, so square footage, or under the Act it's actually square meters, or it can be equal. So every unit will have the same unit entitlement. That's much less common. The standard way, or I should say the more common way here, is definitely by square footage. How you calculate the unit entitlement, so you take your unit entitlement, you divide it by the total unit entitlement, times it by 100, you get the percentage. So example, if it's 53, divide by 1,000, times 100, you get 5.3%. So if you had a $100,000 special levy, it's $5,300 would be your portion of that special levy. So into the depreciation reports. So legislation was passed on December 13th, 2011. There was a 2-year grace period that they gave strata corporations to come into compliance with the legislation, and it came into full effect as of December 13th, 2013. All strata corporations with 5 or more units are required to get a depreciation report, and they're also required to have that updated every 3 years. Now, the caveat to that is that strata corporations can waive the requirement to have a depreciation report done via 3/4 vote at a general meeting. I see a lot of misunderstanding in strata corporations about this particular rule. I've seen a lot of strata corporations have 1/3/4 vote and then they just don't bother getting a depreciation report going forward. Well, essentially that's only valid for 18 months. So if you want to waive that depreciation report, that's something you have to do on an annual basis. And just so everybody's clear, when I say a 3/4 vote, it's 75% of the owners in attendance at the meeting. So if you have 100 units, you don't need to get 75 votes. If there's only 10 people at the meeting, all you need is 8 votes to pass them. Assuming you have quorum, which I won't go into that right now. Depreciation reports will have 3 funding models. Some I've seen more, but typically they're split up into 3 funding models. And this is by no means a rule, and Russ will probably touch on this a bit more, but most of the ones that I've seen, they come with kind of a minimum funding model, which typically isn't really recommended. An adequate funding model, which oftentimes is a bit of a hybrid between spending CRF money and having special levies. And then a full funding model, which is typically so you never have to worry about a special levy and everything should be paid out of the CRF. At this point, there's no requirement for the strata corporation to follow the suggestions in the depreciation report. The only obligation they have is that minimum standard that I talked about earlier with the 10% up to the 25% limit. There has been some rumblings in the industry for the last 3 years that there may be changes, but at this point that's been completely rumors, and I haven't heard of anything actually coming down the pipe as far as that goes. So ultimately, it's completely up to the owners and the council. The council will draft the budget and they'll propose it to the owners at the AGM, but at that point, that's when the owners have a say in how that funding goes. And I've sat in multiple AGMs where somebody's put up their hand and said, you know what, I think our CRF is underfunded. Let's throw an extra $10,000 in there or $20,000 in there. You can have a vote. You can have a majority vote at the meeting and a majority vote to pass that amendment if that's the case. Okay, that's it as far as my rundown goes. Does anybody, do you want to do questions now? Or
sure, yeah. I mean, you're handling sort of more of the legislative side of it. So,
okay.
Any questions on how the Strata Act?
Yeah, if you've got a proxy signed by an owner, then that's just as good as them being there. And another topic that comes up as far as proxies go on a regular basis is currently there's no limit on how many proxies one person has. I've been in meetings where somebody's about 50 or 60 proxies.
I've got 100% proxies.
There you go. You should be just fine then.
So that's good for any. Now, is there a chance of an audit?
Of the depreciation
and who would
report?
do it?
Of the depreciation report?
No, of our meetings and how we conduct them. And all that.
Well, I mean, we're kind of getting off course at this point, but yes, if somebody had a problem with the way that the meeting went, they have every right to go through either through the civil resolution tribunal or through the courts to find some resolution there. Really what the point of it is I'm guessing what the motivation they had with bringing this legislation is there's a lot of people buying into strata corporations, really not doing their due diligence. They wouldn't get a home inspection done. They really wouldn't pay attention to the minutes. So they buy into the strata corporation and find out that a year or two down the road, there was $20,000, $30,000, $40,000 worth of special levies required. So it's almost like a consumer protection measure. Just so, yeah, the strata corporation may not be required to follow it, but at least if you're buying a building with a depreciation report, you have some level of assurance that you're not going to be hit with a huge special levy that's not part of that report. Yeah, there's really no other thresholds from a legislative point of view. I mean, there is some thresholds that you can look at just based on a common sense point of view, right? If you have a 15-unit building, and Russ might be able to comment on this too in a bit. But if you have a 15-unit building, from what I've seen, the prices don't really scale from, say, a 150-unit building down to a 10 or 15-unit building. Obviously, it's cheaper, but you're still paying a lot more per unit. But that's just the economies of scale that go along with being in a smaller strata corporation. I had a gentleman bring up Bearland stratas before the meeting, and that's something that, again, there's typically not a lot of common components in Bearland stratas, so whether or not the strata corporation wants to go ahead and get that report, that's always a conversation. In my experience, I was managing a lot of newer construction buildings, so we're in the midst of going through the warranty process. A lot of those buildings wouldn't get depreciation reports done just because we were getting engineers' reports done on different stuff, but we're still looking at the building every couple of years type of thing. So again, there's no right or wrong answer. It just depends on the strategy of that particular corporation. Well, technically the language under the Property Act is any qualified person, but qualified is not really defined. So I have had strata corporations where a council member basically did the depreciation report. He was an engineer and had experience with it, so that's valid. I have had other strata corporations where they got one done, and then maybe a contractor or somebody within the building kind of looked at it and read the numbers and all that sort of stuff. I don't recommend that, because now you as a personal owner or a council member are taking on that potential liability to save everybody else whatever the $15 or $20 per unit or whatever it costs, right? So really the simple answer is any qualified person, but ultimately I would definitely recommend there is certification for reserve fund planners. I would highly recommend you look at somebody with those qualifications. You know what, again, when the depreciation reports were first coming into effect, there was a lot of these doomsday prophecies that if buildings didn't have depreciation reports, then you wouldn't be able to get financing for a mortgage, and you wouldn't be able to get insurance and all this other stuff. I have not seen that come to fruition at all. I just stopped managing buildings as of the end of July. I had a number of buildings that still didn't have depreciation report, and honestly, it never even came up as a point of conversation when we were renewing our policy. And a lot of those policies were $100,000+ policies, so they weren't small potatoes. So I've seen a lot of the developers are actually, not all of them, but quite a few of the developers are actually giving the strata corporations money to do a depreciation report right off the bat, so they have that. I think the requirement though is still same thing as if you waived it, so you have that 18-month kind of period to get all your stuff in order before you actually get it. As far as when the strata corporation actually takes over from the developer, and don't quote me on this because I'm having to go back in my memory at this point, but as soon as 50% plus one of the units are conveyed, the developer has, I think, 2 months or 90 days to hold the first AGM and hand the strata corporation over to the owners. All right, well, I thank you all for your time, and if I'll hang around until the end, so if anybody else has any questions that come up, by all means, come and see me.